I'm going to turn the fan off. So it's going to get a little muggy in here, but at least you'll be able to hear me. Ted Visner here again, and I've just drafted a letter to the Michigan Supreme Court. The justices individually and in their personal and corporate capacity. I'm just going to read it here, and this is basically the audio version of what I'm sending to them. From Theodore Visner, people of the state of Michigan, Michigan Justice League. To all members, all Michigan Supreme Court justices in every capacity, individual and or otherwise. Date August 1st, 2016. Subject, claim and demand for answer. Answers. I am here making these demands upon this body of government as a man, a people of the state of Michigan, your creator from whom all your lent powers are derived. I have already, but will again for the benefit of this body of both men and corporation, rebut and nullify every assertion, assumption, and presumption made of me, both known and unknown, and extending beyond the actual beginning of my life and for all time, past, present, and future. Any and all presumptions about me in any present, past, or future tense must be in writing and served upon me with suitable time to object and rebut. I stand before you now like Dorothy facing the Wizard of Oz after finding you, this body, behind the curtain. As your creator, I'm here to ask some simple questions and expect truthful answers of this body claiming to be the Michigan Judiciary, claiming to be Michigan's judicial branch of government as established and ordained by the people of the state of Michigan. You have been found to be seriously lacking, negligent in fact, in both your ability, your duty, and your fiduciary duty to effectively regulate yourself as a self-governing body / monopoly, either through willful ignorance or by a festering greed and or by specific design. Since you are a creation of the people, it is the people's responsibility to ensure that you are meeting your intended purpose and if not, alter or abolish you as a body of government. These questions of you are specifically not pleadings and not subject to any formatting requirements. Answering accept or deny or any equivalent will be viewed by the people as a non-answer. You are hereby commanded and ordered by your Creator to answer these questions within 15 days after postmark and return to 856 West Kodietzy Road in Pinconning, Michigan, 48650, care of Theodore Visner, via certified return receipt as proof, and with proof of service completed by any Supreme Court justice that is signed by that justice personally under penalty of perjury. Failure, refusal, or delay in answering these questions posed to you by your Creator will be considered a hostile act of sedition, insurrection, and rebellion against the legitimate government authority that resides solely in the people of Michigan over all three of its branches of government. Questions of the Michigan Supreme Court. Number 1, why is this body blocking the people's access to the courts in Michigan? Number 2, why is this body creating court rules and forcing them upon the people of Michigan with more importance and more significance than Michigan law and the Constitution for Michigan? Why is this body usurping the power granted the legislative body of government when it grants itself the power and authority to create court rules that, according to this body, take precedence via usurpation over Michigan law? Number 3, why is this body allowing chief judges throughout Michigan to create local county administrative orders and enforcing them on the people of the many counties without any oversight from the Michigan Supreme Court and the Supreme Court Administrative Office, or the SCAO, if in fact this body is truly self-regulating? Why has this body allowed Michigan county courts to ban and bar the First Amendment in Michigan courts? Number 4, why is this body perpetrating the notion and suggestion that lawyers and attorneys are licensed by the state when they are not? Why is this body maintaining mafia-style control over the industry of law? Number 5, what is the significance of this court's own administrative orders, and why is this body allowing county courts and county prosecutors throughout Michigan to cite these Supreme Court administrative orders to deny the right of discovery to alleged defendants with regard to crimes classified as misdemeanors in violation of the Constitution and of common sense? Number 6, why is this body allowing informations to be used in cases where grand jury indictments are required for infamous crimes that could result in the loss of liberty to the accused? Number 7, why is this body allowing county court judges to enter pleas on behalf of alleged defendants, allowing county prosecutors to skip the required show cause phase altogether? Number 8, why is this body allowing county prosecutors throughout Michigan to rely upon this body's created court rule in MCR 3.920H, as in hotel, to preemptively deprive respondent parents in Michigan of their unalienable right to due process? Number 9, why are Michigan judges allowed to insist, demand, and order the people to have court-appointed lawyers in violation of Article 1, Section 13 of the Constitution for Michigan? Number 10, why is this body actively working to destroy the people's access to the annotated version of Michigan compiled law known as the MCLA? This body, over the years, has worked to bastardize what is the common law here in Michigan to suit its purpose. The common law, according to this body, is the flexible law that consists of judge-made decisions or case law that changes with the changing times. The intentional design flaws in this are that the people do not have ready access to case law, making the use of case law completely arbitrary and capricious, as only lawyers, attorneys, and other bar members have access to this information. If ignorance of the law is not an excuse, then why is this case law, or the common law, as this body refers to it, not readily accessible to the people of the state of Michigan? Why are Michigan courts and Michigan prosecutors allowing Michigan people to be sentenced before their actual trial with a thing called bond conditions? That was number 11, if I didn't say that. And finally, number 12, for this series of questions to the Michigan Supreme Court, why is this self-proclaimed regulating body doing nothing about atrocities happening in Isabella County and its runaway sheriff department and runaway judiciary, when this body is fully aware of these claims with its own office inside the Isabella County seat in Mount Pleasant? Just a little narrative here. The Michigan Supreme Court has different districts, and in each district they staff these different districts, and one of the districts, I forget the number, is actually housed in the courthouse or county building in Mount Pleasant, Michigan. So it's completely absurd to think that the Michigan Supreme Court doesn't, via one way or the other, know about these claims that I've been presenting, not just to the clerk at the Isabella County Trial Court in general, but I've actually addressed them all individually in all of the districts, and I believe there's 9. All right, this is page 3 of 7, questions expounded. Question 1 again is, why is this body blocking the people's access to the courts in Michigan? That was the question. Here's the expounded. Look around you here in your great hall of justice and notice that there are no people here. Upon my first visit and with every subsequent visit, I am left amazed that all of the glamorous marble walls and the flashy carvings serve only yourselves, and that the silence here within these marble walls is deafening. Fear and intimidation are used as tactics to keep people away on purpose. This body's insistence that the people use practice and procedures established for lawyers to seek your attention and help in finding justice here keep people from seeking justice here. This body has made itself unapproachable to the people of Michigan. The Michigan Supreme Court maintains 9 districts throughout Michigan that are equally unapproachable. People like myself are being utterly destroyed to handicap our ability to seek justice in this system by and through the system itself. Question 2. Why is this body creating court rules and forcing them upon the people of Michigan with more importance and more significance than actual Michigan law and the Constitution for Michigan? Why is this body allowing its own court rules to take precedence over actual Michigan legislation? I'm expounding on it now here. Telling you things you already know. The court rules in Michigan are supposed to govern and regulate those practicing law, lawyers and attorneys, and specifically not the people. Today, your court rules are being imposed on the people while court officers, lawyers, and attorneys seem to be exempt. If the court rules were meant to create requirements of the people, then please explain how the people are to ensure the judge wears a robe and a United States of America flag be in every courtroom, as per your court rule numbered MCR 8.115. While we're on the topic, please explain how the embellished, bastardized, and decorated flags used in Michigan courtrooms meets this Michigan court rule requirement when federal law prohibits the embellishment of the same flag. Are we supposed to bring our own flag to court? While claiming to govern yourselves, you have failed to notice the fact that the captured flag, the gold fringe flag, is used in all of the county courthouses in Michigan. Any tool created by this body that takes on the appearance of law and is used with as much or more force and effect or priority over law is in fact law that has been created by this body without the power to do so and is a usurpation of power, in quotations, stolen power, never given this body. This is an act of treason by the Michigan Supreme Court. Question 3. Why is this body allowing chief judges throughout Michigan to create local county administrative orders and enforcing them on the people of the many counties without any oversight from the Michigan Supreme Court and the Supreme Court Administrative Office, if in fact this body is truly self-regulating? Ignorance? Question mark. Your court rules are being used to create county dictatorships throughout Michigan, and you claim to not know this? Does this body not know that chief judges are creating county policy through administrative orders and imposing these policies on everyone but court officers and court staff? According to the chief judge rule in MCR 8.112, chief judges are allowed to create policy for the internal administration of the court, but they are using this rule to create law as county dictators. These are acts of sedition and treason, and you are regulating yourself how? Additionally, this judge-made county legislation is supposed to be submitted to and authorized by the Supreme Court Administrative Office before these administrative orders are enforced, but they are not being submitted for authorization at all and are being enforced with fines and imprisonment. Not only are these judge-made administrative orders not being submitted for authorization, they are also subjecting the people of the county while exempting the only people they actually were meant to govern. Additionally, this dictated judge-made legislation is being used to cover the criminal acts of county judges by banning and barring the First Amendment from county courts in Michigan to conceal from the people the constitutional violations going on within them that is perpetrated by the alleged judges that work there. This fact creates a conspiracy to willfully deprive the people of rights secured by the Constitution for Michigan and for the United States under color of law, which is a federal crime under Title 18, Sections 241 and 242. And all of this is endorsed and supported by the Michigan Supreme Court through its failure to regulate and deter. Question 4. Why is this body perpetrating the notion and suggestion that lawyers and attorneys are licensed by the state when they specifically are not? Here's the narrative to this. The maintenance of this deception is and has been used to keep people from having full access to the courts here in Michigan with any equal footing, and is an obstruction of justice. Question 5. What is the significance of this court's own administrative orders, and why is this body allowing county courts and county prosecutors to cite these Supreme Court administrative orders to deny the right of discovery to alleged defendants with regard to crimes classified as misdemeanors in violation of the Constitution and of common sense? By morphing the common law to be case law here in Michigan, the Michigan Judiciary should have had the ability to recognize this as a potential problem from the start. Prosecutors and judges in Michigan are now looking to the Supreme Court as if an actual legislative body, to the extent that this court's administrative orders are being used as justification to deny the posturing of a proper defense. This again is an intentional and conspired deprivation of rights under color of law and color of government that is supported and endorsed by the Michigan Supreme Court, while it violates federal criminal law as defined again in Title 18 United States Code sections 241 and 242. Question 6. Why is this body allowing informations to be used in cases where grand jury indictments are required for infamous crimes that could result in the loss of liberty to the accused? It is obviously easier to get a conviction on an information than an actual grand jury indictment, but is this the reason? It is entirely about generating revenue for the state by incarcerating more of its people. Does this state's highest court need me to cite case law now that I do not have access to before it can address this question? I need to make a correction here, because the state's highest court is not the Supreme Court, it's we the people. That would be a great excuse for you now, wouldn't it? Question mark. Question 7. Why is this body allowing county court judges to enter pleas on behalf of the alleged defendants, allowing county prosecutors to skip the required show cause phase of trial court proceedings altogether? Is this body ignorant of these shenanigans? Ignorance would be the only defense if any body that is truly equipped to govern itself. Let me see, I read that wrong. Ignorance would be the only defense in any body that is truly equipped to govern itself. People in the state of Michigan are being prosecuted and persecuted in county court criminal trials without even the prerequisite cause to hold the trial in the first place. Perjured police testimony and sworn affidavits are being used to persecute the people of Michigan without even any hint of any apparent ability to seek redress. Question 8. Why is this body allowing county prosecutors throughout Michigan to rely upon this body's created court rule in MCR 3.920H to preemptively deprive respondent parents in Michigan of their unalienable right to due process? And knowing that this specific court rule exists, county prosecutors are relying preemptively upon this rule to get respondent parents in Michigan into court without due process of law. The specific reliance upon this rule also serves to demonstrate how your rules are taking precedence over Michigan compiled law and the Constitution for Michigan. County-appointed lawyers are appointed upon their specific known reluctance to object to notice defects that trap their clients. In Michigan, there seems to be this presumption that all parents are bad and therefore don't have any due process rights. If this presumption were correct, this would be a non-issue, but this presumption is completely absurd. Children and families in Michigan are being specifically harmed by this Michigan Supreme Court rule that sets out to willfully deprive the people of their unalienable right to due process. This, too, is a conspired deprivation of rights secured by the Constitution for Michigan and the Constitution of the United States of America, to which each member of this body has sworn their solemn oath. Again, a violation of federal criminal law as defined in Title 18, United States Code, Sections 241 and 242. Question 9. Why are Michigan judges allowed to insist, demand, and order the people to have court-appointed lawyers in violation of Article 1, Section 13 of the Constitution? Is this body ignorant of these intentional deprivation of the people's right to present their matters in Michigan courts as both sides of any argument? How could it even be possible for anybody claiming to have the ability to regulate itself to not know what is going on in every lower court? Alleged Judge Mark Duthie would not allow Daniel Austin to proceed in court without a court-appointed lawyer in violation of her unalienable right to present herself in direct violation of Article 1, Section 13 of the Constitution for Michigan. And I recorded this and published this on YouTube for the world to see. And as a result of this, the alleged Chief Judge Paul Chamberlain created county policy absent approval of the Supreme Court Administrative Office that banned and barred the First Amendment from the county court in Isabella County as an act that can only be explained as aiding and abetting in the willful deprivation of rights under color of law and the willful obstruction of justice by the Isabella County Judiciary. Question 10. Why is this body actively working to destroy the people's access to the annotated version of the Michigan compiled law known as the MCLA? I already know the answer to this, in that lawyers, prosecutors, and judges have been handed their ass by people presenting themselves in court using the annotated version of Michigan compiled law. Where the unannotated version creates ambiguity and confusion, the annotated version clarifies. This, combined with the fact that the judiciary has converted the common law into case law and that the people's access to relevant and pertinent case law is non-existent, tidies up the people's inability to effectively use Michigan courts quite nicely and establishes and outlines the conspiracy to do just that. Question 11. Why are Michigan courts and Michigan prosecutors allowing Michigan people to be sentenced before their actual trial with a thing called bond conditions? This is pretrial sentencing that only works to promote the state's desired presumption of guilt. Narrative. Perhaps this state's alleged highest court is also ignorant about this as well. Not only is the state superimposing and unlawfully inserting itself into a contract that it has no business to do between two parties, the creation of bond conditions is a form of punishment that happens prior to any finding of guilt that makes the alleged defendant appear guilty from the conditions themselves. This is pretrial sentencing that only works to promote the state's desired presumption of guilt to more easily generate revenue to the state unfairly. I have been unlawfully and unconstitutionally held on $200,000 excessive bail for allegedly committing 4 misdemeanors where I was denied discovery. I was denied discovery due to this court's administrative orders after the alleged police in Isabella County raided my home and stole or destroyed everything I own in September of 2015. As a condition of my bond, I was not allowed to possess a weapon and was unable to hunt, taking food off my table. As a result, when nothing I was charged with had anything to do with violence or weapons. Later, at my mock trial, a sheriff deputy that claimed to be a witness and testified he had witnessed nothing also testified that a 9mm magazine alone was a weapon, according to him, Clinton Steiner. Meaning, according to him, I would have been found violating a condition of my bond, my pretrial sentencing, had I been caught with a 9mm magazine, even without the actual gun part, and my bond would have been revoked and my liberty further lost. Question 12. Why is this self-proclaimed, self-regulating body doing nothing about atrocities happening in Isabella County and its runaway sheriff department and runaway judiciary when this body is fully aware of these claims with its own office inside the Isabella County seat in Mount Pleasant, Michigan? This question didn't require any narrative. Now to the remainder of this letter. We're on page 6. With this first volley of questions of you, I have removed your ability to claim that you are not aware of these claims for which the people are required remedy. You no longer have plausible deniability with regard to these matters that affect both the public policy and the public trust, and your negligence in the maintenance of both. This self-regulating system was knowingly designed to fail. It has failed, and although many are unaware, a great many are. If this body were actually regulating itself to act within the confines of the law and under the Constitution and not working to obstruct and impede justice, Michigan children would not be being kidnapped by state actors and county prosecutors for federal Title IV money, while specifically relying upon court rules created by this body to willfully and preemptively deprive the people in Michigan of their unalienable due process rights.